Thank you, Mr. Carr. So before we jump into open conversation, let me just clarify kind of procedurally we've got some people attending, et cetera. So this is a public hearing. At this point, members of the commission traditionally interact with the applicant. Actually, normally an applicant has a more interactive presentation, so we kind of interact as we go and question things as we go. But this applicant made kind of a more production related presentation. So why don't we take, if there are any questions for the applicant, now is probably the time to do that. What we should not do, just to set some ground rules so we don't get off track too much. Now is not the time, just as a reminder, most commissioners know this, all of you probably do in your head. Now is not the time to actually argue your opinion as a commissioner. Remember that after we close the public hearing, then we have a time to debate, discuss, and vote after the public hearing. That's when we have our discussion. But Mr. Carr, this is his time now for us to be able to interact with him, ask him questions, clarifications, et cetera. Once that interaction with Mr. Carr is done, which is kind of normal for all applicants, Alice, traditionally staff, provides an opinion, any review, legal advice, et cetera, that we sought. So if there's no questions from the commissioners or after questions from the commissioners, we'll give Alice a little time, and then we'll follow all the normal procedure. We'll then take a moment, a breath, and see if there's any questions or comments from the audience, members in attendance, in the public, because that's normally part of our public hearing as well. After those couple things are done, then we'll be able to close the public hearing, and then we have to move on with our agenda for tonight. And the rest of our agenda for tonight does include time for the commission members to discuss and potentially vote on this application. But that will be later in the meeting after we get a couple other items of business done. So just a recap of our normal process. So I'll take a breath. Commissioners, is there any question, discussion that you'd like to have with Mr. Carr before we go to staff report?
Mr. Carr, you said the number one reason to approve it is because this is what the public have voted for.
I said that this was the number one reason was to fulfill your oath of office, which certainly should reflect the will of the people, which is certainly embodied in the town ordinance. Yes.
Okay. Just to clarify though, how this application was submitted without the extension for hearings, we would have had to vote on this application prior to hearing the will of the people.
I believe the will of the people was represented in the town policy after 3 public hearings. Now it's indelible in the ordinance, but so we had that discussion previously. I think Mr. Hendrick asked me about that. But now you do have an ordinance, and that we have revised the application to reflect the ordinance. And so, I think that stands as stated.
Mr. Chairman, can you hear me?
Mr. Katz, we can hear you.
Yes, I just would like to make the point that contrary to what Mr. Carr said, it is not the purpose of the Planning and Zoning Commission to reflect the will of the people. This is not an RTM. This is a Planning and Zoning Commission, and it's our responsibility to take into consideration all the facts that are presented at a public hearing and try to weigh them and come up with a sensible decision to benefit the town. It is definitely not to represent the will of the people per se, as has been demonstrated many times when a zoning application may receive a great deal of negative publicity and input, and yet it is the responsibility of the commission to approve it because it meets the regulations that we have established. I just wanted to clarify that point.
Thank you, Mr. Katz.
Mr. Chairman, further to that point, as recorded by Mr. Carr, we put a motion in place to shoot down any cannabis established in any shape, manner, or form a while ago. And on the good counsel by fellow Commissioner Mr. Katz, it was presented that we should check with town council so that there are no loopholes. And thus I retracted my motion. And because of it, the town and the people voted that we have no other loopholes. We're not lawyers. To Mr. Katz's point, as well, you know, Mr. Commissioner, we govern based on the regulations that we are required to follow. So based on good counsel, we presented it that way. And thankfully, we got counsel back and the town voted.
Okay, thank you, Mr. Serna. Any other questions or discussion that needs to be had with Mr. Carr from the commission? Okay, Alice, want to give us an overview?
Sure. Well, I had done a summary initially, excuse me, and then Rob, you and I spoke with Tom Beecher concerning how to go forward. My summary says that the ordinance was approved on September 7th, prohibiting cannabis establishments in the town of Ridgefield. The Planning and Zoning Commission have a moratorium in place until December 22nd, 2022. Attorney Beecher has reviewed Mr. Carr's revised regulations. It was suggested that the commission deny regulation change application 822-1 and propose a revision to the current regulation 7.13 and 8.6. This would be a zone change application by the commission, which would necessitate a public hearing. And it's suggested we put on the agenda for October 11th. For a public hearing on November 9th. Due to the late date, actually, that should be October 25th.
Right.
The commission should take time to review the suggestions by the Ridgefield Land Use Attorney, Tom Beecher, to change the wording of the regulations 7.3 cannabis establishments and section 8.6 uses subject to moratorium. And I did send everybody the suggested wording.
Okay. Thank you, Alice.
Mhm.
Just for clarification, I guess, again, just trying to make sure we follow our normal process. Very often at this stage, we would also have consultants that might advise us. And Mr. Carr's made a presentation that's obviously he's obviously an advocate for himself. Traditionally, in an application like this, we might have engaged consultants or others to review the application on behalf of the commission and give us advice, numbers, data, analysis, et cetera. We've actually decided not to do that so as not to burden Mr. Carr with this expense because applicants pay for that. So we're skipping that step that's common. Mr. Carr, do you want to say something before we go to the audience?
Well, I would like to say that I checked the point view today, or whatever it's called, and I did not see anything from Mr. Beecher. I think if he has material, nor did I see the staff report. It seems that if those two documents relate to this application, that the applicant should have a right to examine it. And I've not had that opportunity. Furthermore, when I spoke to Mr. Beecher, I explained to him that as the applicant, we were prepared to make any amendments to this proposed application that he would request, and that would be acceptable to the commission. You certainly have a right to start over again. And to have another public hearing. You can prolong this if you want to. I mean, the ordinance is in fact in place. You can take as much time as you want to. I don't see anything really constructive from doing that. At least having another public hearing. You've had 5 by the Board of Selectmen. I think this is the 3rd one that you've had with me. I think you're beating a dead horse, but that's your prerogative.
Mr. Carr, just for clarification, Board of Selectmen public hearing is not considered testimony to the Planning and Zoning Commission. They're separate entities with a separate legal record. So it's one of the things that we tried to explain to you much earlier in this process. When you wanted us to preempt the ordinance, we explained that actually we need to hold those same public hearings just like the Board of Selectmen had done in the spring. So unfortunately, and I don't make these rules, I'm just reiterating them. Unfortunately, those 3 Board of Selectmen meetings that were earlier in this year essentially don't count for our legal record. And it's unfortunate, but that's just the way it works.
Well, you've had 3. I've extended additional days.
And we did.
You've had 3 of your own. You can have a fourth one of your own. You can have a fifth one, sixth one. I don't, but I think you're
Mr. Carr, I think our intention is to close the public hearing tonight.
right,
And
okay,
And the only reason we actually had 3 is because you couldn't make the video work
Right.
on the first night.
right.
This video that you just showed, you tried to show on the first night, you had problems with the audio. We continued it to a second night, and we didn't have time to accommodate you on the second night. So we had a 5-minute conversation and we asked you to come back here. So now we've listened to your 46-minute presentation that we expected you to make on the first night,
Right.
on the first public hearing. So I apologize that it's prolonged, but again, it's not really us that's prolonged in this case. Is there anything
Well,
else? Mr.
to
Carr?
my, I think to my point about both the staff report and the
Well-
attorney's document not being properly recorded.
Mr. Carr, attorney-client communications are privileged, as you, I'm sure, understand. So we very regularly have conversations with Mr. Beecher where he advises us on applications. And we are his client, planning.
I got it. Okay,
So that's attorney-client privileged information. Staff report, I'll make sure that we do have it posted. I think Alice is probably just delivering it now and needs to post it.
I just did upload it to the file. I apologize. There's a lot of documents.
Yep.
And
And
I
it-
just neglected.
And it's traditional that we present the staff report in the public hearing and post it online. So we'll make sure that's done.
thank you.
And it
Okay.
is now.
All right. All right, if there's nothing else from the commission, I'll go to see if there's anybody in the audience that would like to speak on this topic. I don't see anybody. Okay, again, try to follow normal process here. Mr. Carr, normally we swing around to see if you have any kind of closing comments. There's no further questions from the commission at this time. There's no further.
I'd like to bring up one point if I might.
Yep,
Um,
Mr. Katz.
in the intent and purpose, I think we need to straighten out the language a little bit. If you look at starting with equitable regulation of adult use cannabis in the third line, and in compliance with Ridgefield Town Ordinance 356-1 through the next one, is to prohibit all medical and adult use cannabis establishments as defined. I think you probably wanted to say is to prohibit all medical use and medical and adult use of cannabis and cannabis establishments as defined. It doesn't say that.
Thank you, John. Actually, I think that's one of a number of changes that Mr. Beecher would recommend, and that's why his summary recommendation to us is to deny this application to construct a proper regulation amendment that he's comfortable with, that we should be comfortable with, that complies with the ordinance, rather than accepting Mr. Carr's draft.
I agree with that, but I also think that there's room to discuss the rationale for having any kind of a regulation prohibiting it in the zoning regulations, considering the fact that it is a town-wide prohibition that takes precedence over anything we might do at the table.
That's a good point. Okay, is there any further discussion? Mr.
Yeah.
Carr?
May I just add that you do have a regulation on your zoning, in your zoning regulations that has been outdated by the state statute, now by town policy and town ordinance. And I presume that Mr. Beecher is reflecting that. I haven't seen what he's proposed. I did explain to him that as the applicant, we would probably accept just about anything he wanted to put in there. If you want to start over again, if that's what you want to do, that's your prerogative.
Right. We're very aware of the section. It was actually in your 46-minute video, a discussion that I had with the Board of Selectmen about that section. And we had a pretty thorough review of that section back in May with Attorney Beecher. So we're prepared to edit that as necessary now that the ordinance has been passed, which is what we were all waiting for. Okay. Is there anything further for this public hearing? I'd like to take a motion to close the public hearing.
So move.
Okay.
Make
Mr.
a motion to close the public hearing.
Okay.
Second.
It's moved by Mr. Katz, seconded by Mr. Serena. I heard him first, so we'll give it to him. All in favor? Any opposed?
Aye.
Mr. Katz, you have to verbalize your,
Yes, thank you. I'm in favor of that. since I made the
you
motion.
made the motion, so. Okay, any opposed? All right, public hearing's closed. Thank you, Mr. Carr.
Thank you.
All right, next item on our agenda is 3.1. Now we're, if the public hearing is closed, which it is for A-22-1, this is the regulation amendment application for medical and adult use cannabis establishments in all zoning districts. We can have some discussion on this. We can act on this. We can have a motion to approve or deny.
Rob, can you clarify that if we approve or deny, what that really means?
Yep. So first, just in terms of options, so we can have a discussion tonight. We could table discussion. We have 65 days now that the public hearing is closed. We have 65 days before we need to take a vote. So we don't need to act on this tonight, but certainly if there's consensus and everybody wants to move forward, then we should do that quickly so we don't, have Mr. Carr sitting around waiting. If we approve his application, then we are approving his application in its entirety, in all of its wording, including intent and purposes and the findings of the commission. We're essentially accepting everything that he's presented to us in the documentation, and we're enacting that regulation as he's drafted it. That's what would happen if we approve. We can deny his application. And as Alice has said, that's Mr. Beecher's advice, by the way, that we should deny it, not because we disagree with the fundamental question, because in fact, we have an ordinance and the matter is settled in town, but that the commission and its staff should draft our regulation amendments. And Mr. Beecher would like to do that. So that's his advice. But so we can approve or deny or table, or we can have some discussion and then make one of those decisions. So
So
we need a motion.
I'd like to ask Mr. Carr a question, if I may.
You
still
can't,
there?
because the public hearing is closed.
No, he can, I can ask him a question, can I not?
No, the public hearing is closed. That's
So Rob, to clarify, if we approve the motion or I'm sorry, what Mr. Carr is suggesting, what does that mean? Because fundamentally, it is an ordinance that the Board of Selectmen and the public have voted on. Right?
So-
All we're gonna do at once, if we select to deny it, is then follow up with the suggestion of counsel, Mr. Beecher, to make sure our regulations from the planning and zoning standpoint mirrors the protection. Is that correct?
That's right. It's a relatively minor exercise to,
So
just a few things in our regulations to basically reference the ordinance, which is superior.
So for something like a legislation like this, my personal opinion is that it's important that it originates from the commission and our council. So the town has spoken, the ordinance is passed, and I believe that we should do whatever our council recommends we should do to uphold that ordinance. But I think it should be originating from planning and zoning, not an applicant. And there were pieces of the application that I did disagree with. There was a rendering of a cannabis facility on Main Street if it passed, which we don't even know if that's true. So I would recommend following the advice of council, denying the application, and then following whatever Tom's speaker's advice is that we need to do or not do or update in our zoning laws to follow the ordinance that the town passed.
I 100% agree with Mariah. That's Elizabeth.
I make a
agree with Mark.
motion to deny the application of the special hearing, to deny the application and to change or follow the ordinance that the first selectman and the town has voted on.
Mr. Stern, I think the motion can be as easy as denying the application.
I default to council and chair.
You
I
do-
second the
I'm sorry,
motion.
you do have to make reasons, you do have to give reasons for the denial.
For the denial, yep.
I believe that legal counsel, as well as the fact that the town has voted, the population
Yeah.
was allowed to vote and denied the whatever the heck you call it, the issue that was at hand, that an ordinance was passed by the town by public election, that I vote or I make a motion to deny the application.
Thank you.
Okay. Is there a second?
I agree with that. I was going to ask Mr. Carr to explain why he thinks we should indeed pass this, considering the fact that the town has already forbidden it through ordinance. And I do believe, and I'm not challenging the chair at this point, but I do believe that because the applicant would be the person who would contest whatever was said, and I would be somebody who might contest what he said, that I would have had the right to do that, even though it's post-public hearing. But that's a moot point at the moment, because I think this motion should carry as it is to deny.
If I were to get the applicant right, one of the things he said, John, is that we need to upgrade our regulation. We have something there that's now not dated. So that's one of the things he gave as a reason.
I know he
Update
would
our
like us to do that.
regulation.
And I
don't
do
we
think
need-
that the onus on updating regulations and drafting the verbiage should be on our town council, not on someone outside of the town council.
Yeah, I mean, guys, I made a motion 6 months ago to stop this. And on the recommendation of my fellow respected commissioner, Mr. Katz, it was brought to everybody's attention that we don't want to make a loophole here. And our town council should really be involved. Thus, I retracted our motion. I believe that since it went to the selectmen and actually went to a public vote, the public speaks. If we can't listen to the public, that's a different problem. But beyond that, I agree with Mariah that we should talk to Tom and our public counsel and make sure if there's anything else we can do as the Planning and Zoning Commission under our regulations, we should try and do it to make sure that this is stopped, period, the end.
We should not downplay the point that Mr. Carr brought to us. One of the points that he made, which I think I completely agree, is that if we have regulations on the book that is outdated, part of our job is to update it. And we may not have to go with what he suggested to update it, but we have an opportunity to revisit it, given now that the selectmen had passed, we now have an ordinance that in essence governs the rule of cannabis, and also to be in line with the state law. So I think there's need to update our regulation. That's one point that I would agree completely with Mr. Carr.
Yep.
It's not dated.
Yeah, I agree with that point. I think we all agree with that point. You know, that when we established this moratorium, I think we all recognized that the issue needed to be settled and quick. When I was made chair in late November, I went to a Board of Selectmen meeting in January, and anybody can pull that record. Mr. Carr is very good at pulling old videos. I actually said there, and I presented them a list of top priorities that I thought they needed to focus on. And this cannabis issue was one of those, and that I pointed out to them that the clock was ticking, and that when we passed the moratorium, the reason that we passed the moratorium, which is actually in the video, I said it myself, and it was in Mr. Carr's video, we passed that moratorium because they signaled their intent to pursue an ordinance, and they needed to act quickly. They wanted to have public hearings, and then they needed to go get an ordinance done. I regret that we had a bit of a back and forth in May and June over, them trying to essentially not do an ordinance and ask us to pass the regulation. And our response basically was, you should pursue completion of your ordinance, which they did successfully. And frankly, I think Mr. Carr, while I respect his work and he did a great video, I think a lot of this at the end of the day was one man's work. And it was, seemed to me a little bit of publicity here. And the fact that we're spending continued time having this discussion after there's a definitive ordinance in place seems to me just continued publicity. And I don't really appreciate that. I certainly don't agree with his ordinance the way it was drafted. I don't agree with the intent. I don't agree with a lot of the background that he provided. I certainly agree that we need to now comply with the ordinance. That's clear. That's black and white. But Mr. Carr's drafting of the language is not something that I can agree to personally.
Rob, towards the end of the meeting, you can, if you would like to schedule a time to have a public hearing over the new wording that Tom suggested, we could do that as well for the end of October.
So we have a motion on the table to deny the application. I think the reasons are that we have advice of counsel that we should be drafting our own regulation, and we don't need Mr. Carr's help in drafting our own regulation, even though he's offered. Thank you very much. I think administratively, it's not the preference, it's not Mr. Beecher's preference to have Mr. Carr as his partner in drafting. And that's advice of counsel. Furthermore, again, at least as far as I'm concerned, I don't know if the commission will agree to this, but I'm just flat out not comfortable with Mr. Carr's drafting the way it is in his presentation, his findings, and his reasons even for the.
Yeah, I mean, Rob, amongst us, that was a production.
I agree with Rob's sentiments, and I do believe when the ordinance was going through the continuation of this and us dedicating so much time when the town was going to vote on it, which I think the town voting on this is ultimately, that is the decision. That is more important than pushing through this permit. So I all of Rob's comments, I completely agree with and echo those.
Okay, I'm just gonna second it. Can you just vote?
Yeah, we can. It's been seconded. Alice, do you feel like we have sufficient reason for the record?
Yeah, I just have to create updates to follow the ordinance, and it was passed by public vote. And on the opinion of council for the commission to draft their own regulations. That should be sufficient.
So moved.
I would just like, I would be voting against the ordinance no matter what council said about it.
Thank you, Mr. Carter. Thank you, Mr. Katz, for the record. And, by the way, I should add before we actually move to vote, to be clear, I think Mr. Carr didn't, in my opinion, didn't do an honest job in terms of the conversations that were happening in May and June. I think unlike the Board of Selectmen that was fairly strong, black and white against this ordinance, I feel like you, my fellow commissioners, signaled a lot more middle ground. There were some people definitely for a ban. There were some people very against the ban. By the way, we had Mr. Dowdell has already voted against the moratorium. So we have people on the record on both sides, and we have a lot of people in the middle. And I feel like the outcome, if we had needed to regulate this ourselves, wouldn't have been necessarily black and white. So I'm not sure that Mr. Carr would have been successful if we had voted ahead of the ordinance.
Rob, can
I
I
agree.
just suggest, Mr. Carr is a player or whatever, it seems, and I'm a new member to the board in the town. The production, the theatrical, and I apologize, it's opinion on my behalf, and I will couch this as opinion. His swaying of political aspects, I think we have to be, as a board, very conscious of time we allow and time we don't allow for political banter. Again, respectfully to my fellow commissioner, Mr. Katz, we are regulated by regulations, right, John?
The regulation says there's a motion on the floor and it needs a vote before you discuss any other topic.
Okay, so there's a motion been made and seconded. I'll call the question. The motion, just to clarify, is to deny the application A-22-1. All in favor of denial.
Aye.
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 Any opposed? None opposed. It's unanimous. Thank you.